Ladies and gentlemen, welcome to Hamburg. Being from Hamburg, I'm very pleased that our city decided to host this conference, and so my warmest welcome to you as well. Why are you here? Certainly not just because of the weather, and certainly not just because you want to see some beautiful sights of Hamburg. I guess you came here to Hamburg for the reason to explore some opportunities which you or the company which you are working for might have. You want to make a decision about expanding your businesses, improve your services, or maximize your chances. But the more you look at these opportunities, the more you discover that there are limits. Limits of financial means, limits linked to the protection of the environment, geographical limits, and last but not least, legal limits. You cannot just do what you want because the law restricts your opportunities. So any business decision needs to reflect your legal rights and obligations. Without considering the law, you cannot evaluate your chances and obligations and challenges. Whenever you consider the legal framework in which you act, there are two aspects: the substantive law, regulating the rights and obligations, and the procedural law, regulating how these rights and regulations are pursued. Normally, you have the possibility to make a choice both in the selection of substantive law and in the procedural law. In many legal aspects connected with port business, you cannot, however, avoid dealing with the local law which is in force at the place where the business is done. Lawyers use the term lex fori, meaning that necessarily the laws of the jurisdiction applies in which a legal action is brought. This is particularly the case in administrative law, real estate law, environmental law, labor law, and procurement law. Here you do not have a choice. You have to deal with the local laws, and you have to pursue your rights at the local courts. In these matters, you cannot go somewhere else to fight for your rights. This is different in contract law. Contracts, especially contracts between parties from different countries, normally allow the parties to choose both the applicable law and the forum where disputes are to be decided. The rights and obligations differ depending which national law is to apply. And even if there is some unified international law, Michael explained a little bit about that, such laws are often interpreted differently in each country. One example for differences in countries is the fact that in Europe you do not have, for instance, punitive damages. Moreover, the damages granted for pain and suffer are much less in Europe than, for instance, in Northern America. So this is an example for differences in substantial law. But differences are much more obvious in procedural law issues. The first question you have to think about is whether you prefer arbitration to state court litigation. In still too many countries, you will find In many countries, you will find a very efficient and qualified judicial system, but not in all countries. In still too many areas of the world, courts are slow, expensive, unpredictable, or even corrupt. Here you are much better off when having an arbitration clause in your contract. Arbitration is always confidential and normally has no possibility of an appeal. In fact, this is slightly different in the UK. With one instance only, you save time and money. Another advantage of arbitration awards are, in contrast to state court judgments, enforceable in almost any country in the world. And arbitration proceedings are very flexible. You can choose the procedural rules. You can pick an arbitrator who is really familiar with your business. You can have the proceedings conducted in the language of your choice, and you can determine which substantive law is to be applied. All this is not possible in state court proceedings. If you have opted for arbitration, you again have two alternatives. You could choose rules of procedures governed by civil law, as it is applied in continental Europe, or opt for common law, as it is known in Anglo-Saxon countries led by England. There are two obvious differences between civil law and common law procedures. Franz already mentioned some, I will add some more. The first one relates to fact findings. It is hard to comprehend for anyone who is familiar with the Anglo-Saxon system that continental Europe does not know any disclosure or pre-trial discoveries. This saves time and money. But this also means that anyone starting litigation or arbitration does not know the cards, or at least not all of the cards, which the opponent is holding in his or her hand. And you do not know at the beginning of a lawsuit which witnesses will be heard, let alone what they may tell to the court or the arbitration panel. The European legal system compensates the missing procedure to obtain pre-trial information from the opponent by extensive rules of evidence, which often shift the burden of proof on the defendant. The second difference relates to the role of the judge or arbitrator. It is my understanding of litigation and arbitration under common law that two parties enter into a ring for a fight, the judge or arbitrator being the referee observing that procedural rules are complied with. The parties then have their day or their days in court, and the party wins which had the better case or the better lawyer. The outcome of the litigation depends on the presentation by the parties at the trial, and it is the role of the judge to render a judgment and the role of the arbitrator to render an arbitration award. In continental Europe, on the other hand, we do not have such an adversarial system, but a mixture of adversarial, conciliatory, mediative, and inquisitorial elements. In particular, the judge and the arbitrator take a much more active role in guiding the parties by actually determining factual issues with the expectations to find out what really happened. Judges are more inclined to do justice beyond securing a fair trial. Consequently, judges and arbitrators in continental Europe have a greater tendency to make the parties reach an amicable settlement. In Germany, for instance, they are even forced by law to do so at any stage of the proceedings. Judges and arbitrators even make specific suggestions for an amicable settlement, something that is unheard of in common law countries, where you would have to start totally different proceedings, such as mediations, in order to get some assistance in this regard. In the first hearing, which may be very short, the judge in Europe or the arbitrator will explain his or her views and tell the parties exactly which points are considered relevant and which points may need further elaboration. Thereby, the whole dispute is narrowed down to possibly only one or two specific issues which are actually decisive. This again makes procedures time efficient and less expensive. I conclude. As you can tell from my above remarks, I am, maybe not surprisingly, an advocate of my own system. But even if I try to take a neutral position, I believe that it is fair to say that in contract negotiations, you should consider arbitration or litigation in Central Europe as a serious option. You should definitely consider arbitration in Hamburg. Hamburg is a good place for this, with a long tradition in maritime dispute resolution, with clear rules and excellent arbitrators. Tried and tested in hundreds of cases. If you wish to have some further information on the options you have when choosing a proper law and a proper procedure, I can highly recommend two websites which both provides overviews in various languages. The first one gives a very good overview of the most important features of German law and is called www.lawmadeingermany.de. The second one is the website of the organization of which I am Secretary General, that is the German Maritime Arbitration Association. And this website is called www.gmaa.de. It also explains what other means of dispute resolutions are offered by GMAA. Thank you very much.